Good afternoon, and thank you for joining us today for the second of our 4 talks in 2024 in our Professional Advisor Speaker Series. I want to extend a very warm welcome to Neil Solarz and Kimberly Goldman Fagan, who agreed to do this today. I really appreciate the time you took to prepare the presentation and to be here to do the presentation. You should have received earlier today an email with their bios and the outline that they're going to use for the talk today in case we aren't able to share it for some reason. Hopefully that won't be a problem for anybody. Many of you probably know about our donor advised fund program and our endowment program, but you might not know as much about our consulting program that we do with family foundations and private foundations. So I wanted to share a quick 90-second video that outlines how we work with some of those clients. Audrey, would you mind sharing the video?
When I started with Mr. Rautenberg after he founded the foundation, he brought in the Jewish Community Foundation as an advisor, and I've found over the years that I've really gotten tremendous benefits from consulting with the various people from the foundation because I have really no knowledge about how to analyze a charity, and they've always done an excellent job of really digging in deep to various charities. They follow up extremely well after we make the donations, so I've been very impressed with what they've done and how they've helped me over the years. I have always felt that the Jewish Community Foundation really was great in making recommendations and helping people who have a very philanthropic feeling, but they don't know really how to execute it. And so the Jewish Community Foundation has really helped those individuals execute.
If any of your clients or you would like to know more about how we use this consulting service to help our families, please be in touch with me after today's program. And lastly, before Kimberly and Neil begin, I want to remind you to please send me questions during the program. Kimberly and Neil said they'll answer questions while they go. So use the chat function at the bottom of your screen to send questions, and I'll interrupt them to get the questions asked. And if you want to write to them directly, go ahead. I just don't know if they'll see them while they're doing the presentation. With that, I turn it over to the two of you, and thank you again for doing this presentation.
Thank you, Steve. I appreciate that. And good afternoon, everybody. I'm Neil Solarz. This is my colleague, Kimberly Goldman Fagan.
Names and flags.
Yeah, we're both with Weinstock Manion. Our firm is a bit unique in that we are a dedicated specialty firm that only does estate planning, probate and trust litigation, and post-death administration. As our firm has been around for over 60 years, many of our clients are beginning to grow older, as we all are. And today's program is entitled Legal, Ethical, and Practical Issues when a client is losing capacity. And because of our client base, Kimberly and I face this issue on nearly a daily basis. Ordinarily, these issues are not a problem if we're dealing with nuclear families where everybody has an integrated estate plan and everybody is on the same page. But the issues do arise when those things are not in play. One of the reasons we do estate planning is to avoid these issues. For example, we do a revocable living trust not just to avoid probate, but to avoid a conservatorship when somebody loses capacity. And so with a funded revocable living trust, a successor trustee is named who can step up and take control of the incapacitated person's assets and administer them for that person's benefit, hopefully without court involvement. Similarly, an advanced healthcare directive designates an agent to make healthcare decisions if the principal loses capacity, can't make medical decisions, again, avoiding a conservatorship of the person. So those are key tools in our toolbox to avoid court involvement. But when we don't have those tools, and when an issue arises with somebody losing capacity, that's what we're going to be dealing with in today's program. So with that, I'm going to turn it over to Kimberly to tell us a little bit about the governing law.
Okay, so diving right into the Due Process and Competence Determinations Act, a little bit of a mouthful, so we'll call it the DPCDA. This codifies standards for a court to use in determining whether a person has the capacity to perform particular acts in a variety of contexts. So it starts with the presumption that every person has the capacity to make their own decisions and take responsibility for their own actions. And this presumption affects the burden of proof. And as you'll see in the pictures, there's different levels of capacity that are required for different documents. So for example, the capacity to execute a will is different than the capacity to contract or get married or convey property or make medical decisions. So we can go to the next slide. So just to highlight difference between testamentary capacity and contractual capacity, the bar for testamentary capacity is much lower. And this comes up in litigation when, because it depends on the level of capacity that somebody is found to have could change the who gets what. So an example of this is in the case Anderson v. Hunt. So there was a married couple, and they originally had everything going to their joint children. And the husband's wife had passed away. And then he, after suffering a stroke, he got into a new romantic relationship with somebody else. Her name's Pauline. And he decided he wanted to leave 60% of his estate to Pauline. So he amended his trust, changing the dispositive provisions. And after he passed away, his children contested the amendment, and they sued to invalidate this amendment, saying that their father did not have capacity to make this change. And originally, the probate court had said they found that his name is Wayne, that he did not have capacity, but that's because they were looking at the standard for contractual capacity, and that's a higher standard. So the Court of Appeals then reversed the judgment and said, actually, he did have capacity because the standard should have been the lower bar for testamentary capacity. And if you just look at the definition, it's a very low bar. It says a person cannot understand the nature of the testamentary act, understand and recollect the nature and situation of the individual's property, remember and understand the relationships to living descendants, spouse, and parents, and those whose interests are affected by the testamentary instrument, or either that or a person suffers from a mental health disorder with symptoms including delusions or hallucinations, which can impact how the person would devise property.
So the court basically is saying that the trust in this context is like a will substitute.
Mm-hmm.
It's a testamentary instrument.
Right.
Yeah. Next slide, please. One back.
One back.
I don't know what to so here. This is one. The next one.
Yeah, there's this. No, go back and back. There should be one in between. Okay.
I think
it's not there.
It got flipped,
All
so
right.
this is first, and then it'll be that.
Okay. So undue influence. Go forward, please. Undue influence is one of the grounds for attacking a testamentary instrument. Typically, the contests show up as either the person lacks capacity, as Kimberly just talked about, or is under the undue influence of somebody else, a predator. So undue influence means, under the Welfare and Institutions Code, excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will and results in inequity. And what courts look to typically in figuring out whether somebody is subject to undue influence, vulnerability. So if somebody is elderly, if somebody is dependent on somebody else for their support and care, that makes that person vulnerable to third parties. The person exerting undue influence, does that person have some kind of authority over that person? Is that person isolating the person from other family members? And as a result of that undue influence or tactics by the influencer, does there appear to be a result that ordinarily one would not expect? For example, a sudden change in the person's estate planning. So under the probate code section 86 simply adopts, if you will, the Welfare Institutions Code definition for undue influence. And this happens all the time. I mean, we have clients who, as they get older and as they become more dependent, as a result of infirmity, become susceptible to predators, whether the predator is a caregiver, whether the predator is a child, whether the predator is a new significant other that comes on the scene suddenly and begins to exert influence to have that person change their estate plan. This often comes up when we're contacted by children, warning us that this is happening. Maybe one child complaining about another child. And this presents all kinds of issues for us as estate planners, which we're going to talk about the ethical rules next, but that's how this comes up.
Yeah, and then just one more thing to add, and also, as Neil was saying, how it comes up with claims of incapacity. In that case that we were just talking about, Anderson v. Hunt, the children not only claimed that their father had incapacity, but that Pauline, the romantic spouse, was exerting undue influence, and that's why the amendment had got amended incorrectly. So they often come hand in hand in litigation. Next slide, please. So just wanted to comment that the ethics rules matter both to protect clients and to protect lawyers. So a violation of these rules could be grounds for discipline or malpractice. And it's important to learn these because they're actually not always intuitive. You might think that they would be, but the rules vary state by state, as we'll get into, and particularly how California is different. And another thing to think about is the statute of limitations for estate planners is especially long, because in other areas of law, the statute might commence when the service ends. But for us, we could finish an estate plan when somebody's in their 30s. Hopefully they would update it at least every 7 years. But if they don't, I mean, we're exposed for a really long time if they pass away in their 90s. So we want to make sure that we know the rules to properly get everything done and protect ourselves and the clients.
So let's go to the next slide. Okay, so some of the ethical duties, not all of them, but some of the ethical duties we have as attorneys in representing our clients is the duty of loyalty, which includes the duty to avoid conflicts of interest that are adverse to our clients, the duty to perform our services competently, the duty of keeping our clients informed, and the duty of confidentiality. So the duty to preserve confidentiality often comes up when an elderly client, and this has happened to me on a number of occasions, tells me, I want you to talk to my child so-and-so and leave me out of it. I don't want to be involved. Do whatever child X says, and that child X could be a caregiver or any third party. And the client seeks to withdraw from participating in the process. And that really is a problem, because our duties are owed to the client, not to a third person. And if we learn of something that's adverse to our client or adverse to what our client's estate plan currently is, and we seek to communicate that to our client, and the client simply says, I don't want to know about it, do whatever my child or my caregiver says, we're at a crossroads of maybe having to withdraw from representation. So we have to keep our client informed, which has to override the client's desire to stay out of the estate planning process. We also have a duty of loyalty. So if a client's child, who is this person who is running the show, is also our client, then we have a conflict of interest. Because if we learn something adverse about our client from the child who is also our client, we have a duty to disclose that, and vice versa. And so when this happens in our office, and hopefully it happens in your offices as well, if you're practicing law, we have the child and we have the client, the parent, execute what we call a multi-generational conflict waiver, where each consents to separate but concurrent representation, so that our representation of each of them is separate, meaning we preserve confidences and we won't disclose what we learn from one of them to the other without authorization to do so in advance, even if that communication is adverse to the interests of the other client. Without that, we have an unavoidable conflict of interest, and again, we may have to cease representation altogether. Our duty of communication comes into issue if a client is so infirm that they lack the ability, the capacity to understand what we're trying to communicate. And so if a client can't communicate effectively with us and can't understand what we're trying to convey, we may no longer have a client, and we may have to cease representation. So the question often becomes, if we're meeting an elderly person for the first time and we're considering whether to engage that person to do estate planning, does that person even have the capacity to engage a counsel? And we're going to talk about some of the common red flags now, if we go to the next slide. When we're meeting with elderly clients or potential clients, these are some of the things that we need to pay close attention to when considering whether to actually represent this person. Does a client, the elderly client, want to disinherit a child or another natural object of their estate plan? Does that client have difficulty communicating? Is that client not oriented to time and place? Is that client not giving appropriate responses to questions? Does this client or potential client, as I just mentioned, defer to a third party? Bring in somebody that is the client wants to drive the process rather than the client himself. Is the client involved with a relationship that's I hate to use this term as it's politically not correct, but questionable relationship, or a relationship that may raise some eyebrows, like somebody that's 40 or 50 years younger, and changes are desired to reduce what the family is getting in favor of this new person. So this may be, all of these things may be innocent, they may not be innocent, but they're red flags that we need to think about. Next slide. So what we're going to do is we're going to run through a series of what we consider common scenarios, hypotheticals, and how we would deal with these things as they come up. So Kimberly has used names that apparently have something to do with the Severance TV show that I have never, Succession, that I have never seen. But she tells me these are the names that are used. So the first scenario, elderly client Logan Roy wants to disinherit his son, Kendall Roy, and he brings his daughter Shiv to the estate planning meeting. Shiv has been taking care of her dad, monitoring his medications, and bringing him to doctor appointments over the past several months. Logan's existing estate plan, which has been in place for many years, treats all of his children equally. So,
why do you think this is a red flag?
So, good question. What are the red flags? So here we have Logan showing up with his daughter who seeks to benefit from the change he wants to make to his estate plan. And the daughter is not our client. And she should not be at this meeting, for sure. So this comes up whenever the client is accompanied by somebody benefiting from the estate plan, and there's a change that is desired to be made in favor of this particular person to the detriment of other people that are not at the meeting. So what can we do to ameliorate this process? Well, for one thing, we can ask her to leave, which I do all the time. And whether they sit in the waiting room or ask them to go downstairs and get coffee, that's what I do, because I have to meet with the client alone. And I have to ascertain whether the client, to the best of my ability, and I'm not a geriatric psychiatrist, but to the best of my ability, try to ascertain whether this client has capacity and whether this client is being unduly influenced.
Right.
And I'm going to ask questions to make that determination.
You say open-ended questions.
General questions. I would ask the client to identify the nature and extent of their estate, who their family members are, why this change is desired, what's the relationship like with the other children, and try to understand why this is happening. And again, there may be a perfectly reasonable explanation. Oftentimes, the other children may be estranged. They may not have had any communication with Logan for years, while Shiv has been attending to dad innocently, has been taking care of him, and dad believes that he wants to just benefit Shiv over the other children. And as long as dad has capacity to make those decisions and is not being unduly influenced, he should have the right to do that. Now, if we are concerned about capacity issues, and maybe even whether or not we're concerned about capacity and undue influence issues, given the fact that Logan is an elderly client and Logan wants to upset his estate plan scheme, which has been in place for many years, and disinherit some or more of his children and just benefit Shiv, I'm likely to recommend that Shiv be examined by a geriatric psychiatrist, so that I get a expert opinion, which I can keep in the file, that to the best of the expert's opinion, Logan still has testamentary capacity, and Logan appears to be free of undue influence when making these decisions.
Right. Just to
And we would
prevent litigation later too.
we would urge Logan to go through that exam, and it's really for not only his own benefit, but for the benefit of Shiv, because that is likely to help protect against the litigation risk that may come later when the other children learn of this change in the estate plan.
And
So
what would you do if Logan, when you met with him alone, he just completely appeared to not have capacity?
if I made the decision, again, admittedly, I'm not a medical doctor, but if I made my own observation that this person lacked capacity, was obviously being unduly influenced, I would not do the amendment.
Because I know we've had some times together where it seems really obvious and clear.
Right.
You don't need a geriatric psychiatrist to make the determination.
Kim, what do you think about videotaping our meeting with Logan Roy? Some people like to do that to show capacity and lack of undue influence. What do you think about that?
I know it's controversial because some people like to do it, but we don't do it. And part of that is that just administratively, it would be really difficult because if we only did it during the times when we thought there was some kind of concern, they could use, the opposing person could use that fact to say, well, if you videotaped it, you must have had a concern that they didn't have capacity. And the only way to get past that concern would be to videotape everyone, which would be really administratively difficult. So it makes more sense not to do it at all. And then on top of that, say we did do the video and then people are analyzing it and there are some signs that the person maybe lack capacity because sometimes it's really a gray area. They could use the video against our client. So I would say it's best not to.
Yeah, we have always considered videotaping a double-edged sword, depending on, the eye is in the beholder kind of thing. And so we've never done it. I know other people do it. But our practice, when we have the real risk of litigation in this kind of scenario, is to have that person examined by a geriatric psychiatrist.
And I think one thing that I struggled with when we were first dealing with potentially incapacitated clients was it's really hard to tell that person that you want them to get an exam because it's a sensitive topic and they might feel insulted because everybody wants to feel like they have capacity and they have control over their lives. So I think
you're right, but I tend to get the client to get over that by saying, this is really for your daughter's benefit.
Right.
We're doing this to protect your daughter from litigation and to uphold your estate plan, your desired testamentary wishes, if it's attacked later. And that usually gets them over the hump.
Right, that's good. It's a good point because then you don't even have to get into what you think about their capacity, but you could in some situations.
But let's go to the next scenario.
Okay, so in this one, the child of the client seeks to initiate a conservatorship over our client. We've represented Logan Roy for years and noticed he may be losing capacity. His son, Kendall, calls us about his concern that Logan may have dementia and may be taken advantage of. Kendall asks us to initiate a conservatorship proceeding to make Kendall Logan's conservator. Okay, so this is a situation where a lot of the ethical duties we talked about come to mind and some override others in this situation. So like on one hand, we want to protect our client and maybe we think Kendall has Logan's best interest at heart. He wants to protect his dad.
Let's assume he does.
Assuming he does,
yeah.
Right? He wants to help this. We want to help the family out, and Logan's our client. We want the best for them. And we know we have this ethical duty to perform services competently. But then on the other hand, we have a duty of loyalty to Logan. our client, and a conservatorship is going to be a deprivation of his liberty. And then we also have a duty of confidentiality, as Neil discussed earlier. And the personal information that we know about Logan might inadvertently leak out to Kendall during the course of trying to get the conservatorship, or even become even more public. And then we'll discuss whether we have a duty to a client with diminished capacity, because it's a bit different in California. So in this case, the duty of loyalty and the duty of confidentiality are paramount here. And you might say it even overrides duty to perform services competently. So the California State Bar Formal Opinion 1989-112 says, without the informed written consent of the client, a lawyer may not initiate conservatorship proceedings on the client's behalf, even though the lawyer has concluded that it's in the best interest of the client. And the reason is that this would breach the confidences of the client, and it would constitute a conflict of interest. So basically, it would also violate the duty of loyalty. So since this is an impermissible conflict of interest, we're not going to be able to help Kendall initiate a conservatorship proceeding against our client, even if we think that this would help the family. Next slide, please.
So we would tell Kendall that.
Right.
And we would tell Kendall, while we can't help him, he's going to need to seek the advice of other counsel.
Right.
Yeah.
Okay, so we touched on whether there's a duty to a client with diminished capacity. So California has no rule specifically addressing the obligations of an attorney who represents a client with diminished capacity. When the California rules of professional conduct were overhauled in 2018 to align more closely with the ABA model rules, this was the only one of 70 proposed new rules that was rejected, and that's ABA Model Rule 1.14b. So this rule allows the attorney to take protective action when the attorney reasonably believes that the client has diminished capacity and cannot adequately act on behalf of their own interests. So California State Bar Formal Opinion 13-0002, it's an opinion that addressed the situation. It says, when the client's diminished capacity exposes the client to harm that the client is unable to recognize or prevent, the lawyer may not take protective action involving disclosure of the client's confidential information without the client's informed consent. So a lawyer advising the competent client, this is way in advance when they do have capacity, the lawyer might want to recommend that the client give advance consent to the protective disclosure of confidential information. And this opinion actually mentions this, that you might want to give advance consent. And so that if the client suffers diminished capacity in the future that exposes the client to harm, they have consented during a time when they had capacity, that they would be okay with some of their confidential information being leaked in order to protect them. But you have to be careful if you're doing that. You might want to put it in the engagement letter, but it does say in the opinion it has to be properly limited and informed in order to be ethically proper. So if you're going to put it in the engagement letter, definitely make sure that it's limited and informed.
And this is not something we've done in our office. Maybe some of you have, and I'd be interested in finding out, but it seems to me that this could create a lot of issues. And it would only be used if the client was totally incapacitated, because otherwise we're just running too big a risk. So I don't know. I'd be curious to hear from some of you that actually do this practice, how it's worked out.
Yeah, me too. So next slide, please. Okay, so another scenario. Now we're on The Sopranos. So a child initiates contact to take parent on as a client. Tony Soprano thinks his mother, Livia, is losing capacity. He learns that she never did any estate planning and reaches out to us to take his mother on as a client. Livia hates lawyers and instructs us to only communicate with Tony regarding all aspects of her estate planning and do whatever Tony instructs us to do. So Neil sort of mentioned this scenario earlier. In practice, this is a really risky situation and a client that we might not want to take on, especially if there's even more risks, like wanting to change the dispositive provisions to only benefit the child that's communicating with us. But even without that, as we discussed, we have that duty of communication. And if we're only communicating with Tony, then we're not, it might cause us to inadvertently violate that duty of communication. And then there's even just a risk in this situation that we're going to carry out Tony's wishes instead of our client's wishes, and our client is his mother, Livia. So he might start asking us questions that would benefit him instead of her. It's just a sticky situation that we might not want to get into.
Yeah, and in this situation, it is imperative if a client tells you to communicate or share information with a child or other third party, that you get that in writing and you put it in your file, so that you have something that indicates that this instruction was actually coming from the client and not coming from the third party. That's critically important. And of course, like in any situation, this scenario is telling us that Livia is losing capacity. So depending on Livia's stage of losing capacity and what her estate planning entails, we may now want to take this on as a client. I mean, Kim and I are involved in somebody right now that we don't have a previous relationship with, that she was brought in by a daughter. And the proposed estate plan is perfectly innocent. It's to benefit the kids equally, nothing crazy going on. But this person that introduced us to the parents has been suspiciously involved in the communication, serving as a referee. And we made the decision ultimately just not to do it.
It's not worth it.
It's not worth taking on and taking on that risk of not having effective communication with our own client.
Right. And what would you do if in this situation Tony was an existing client, and then he brought his mother Livia, who was not yet a client, and then asked us to take her on and do her estate planning?
Yes,
we already have this duty of loyalty too.
Yeah, I mean, obviously that's a conflict of interest, right? And so if Tony is already a client and he brings his mother in who's not yet a client, and she wants to benefit Tony more than or over than siblings or other family members, I would tell Tony, who is our client and whose interests we are acting, that it would be better and really, in my opinion, mandatory that we not do Livia's estate plan, that we send Livia to someone else who doesn't have this divided loyalty, because I want this estate plan to be as free from attack, contest based on undue influence, lack of capacity, etc., as possible. And if we do that plan and we have a duty to Tony, I'm concerned that makes the plan that much more suspect.
Right. So ultimately, it's doing the best thing for our client,
Correct.
Tony, by sending Livia's plan somewhere else.
Correct. Okay, well, I think we're on to the next slide. Okay. So the next couple of slides discuss how we can do estate planning for a client that may lack capacity or does lack capacity. And so the first scenario deals with conservatorship. New client Pete Campbell calls us about his mother Dorothy, who has an estate of more than $50 million. Dorothy has done no estate planning and has not even executed a will or a living trust. She's in a skilled nursing facility, suffering from advanced dementia, and is unable to make any financial decisions or implement any estate planning. Pete is worried about avoiding probate and saving estate taxes on his death. Pete knows that we have an election on Tuesday that may tell us more about the scheduled reductions in the gift and estate tax exemptions, and wonders what we can do for his mother and her children to avoid transfer taxes, avoid probate, etc. And so, because there's no plan in place, if you remember the introduction to this program, we talked about avoiding conservatorship through a living trust, through an advanced healthcare directive. Poor Dorothy has none of this. So if we're going to do any estate planning for Dorothy, we're going to need to implement or initiate a conservatorship proceeding for her person and estate. And so my advice to Pete is going to be, we need to do a conservatorship. We can petition the court to have you appointed conservator of your mother's person and estate. And concurrently with that, we're going to be asking the court to allow you as her conservator through what's called substituted judgment, which is set out in Probate Code Section 2580, to implement an estate plan on your mother's behalf. The idea being the petition for substituted judgment would advise the court that this is the estate plan or steps that Dorothy would take if she had the capacity to do so. So through substituted judgment, not only can we get a court order allowing us to establish and fund a revocable living trust, but we can also get gifting authority, and we can get authority to create irrevocable trusts to receive those gifts. And we can leverage Dorothy's estate and gift tax exemption by making gifts of minority interests in real estate or other assets where we can make those gifts more powerful. And the court is going to need to know that Dorothy could make those gifts taking advantage of available exemptions in the law from estate and gift tax. As I said, avoiding probate. She can do those things as long as doing so doesn't negatively impact the ability of her estate to continue to care for her. So in our substituted judgment petition, we're going to have to demonstrate to the court that Dorothy has sufficient resources, even after making the gifts that we're asking the court to authorize. Dorothy's going to have plenty of money left to live for the rest of her life comfortably in the skilled nursing facility, and all of her needs will be more than adequately taken care of. We're going to need a budget. We're going to need to know what Dorothy spends every month, and we're going to need to build in a large reserve for contingencies. We're also going to need anytime you file a petition for conservatorship, it's a court supervised proceeding. There is a court appointed counsel for Dorothy that will be appointed by the court, who will interview Dorothy, interview Pete, interview other family members to make certain that this proceeding, this conservatorship proceeding, as well as the substituted judgment petition that is contemplated, are in Dorothy's best interests. The court will send out a court investigator who will conduct a similar investigation and report back to the court. And this is all to protect Dorothy, because with a conservatorship, we're taking away Dorothy's liberty to make decisions for herself. And that's why the court is so concerned and builds in these safeguards to make sure that this is a proper proceeding. And all the things that we're asking the court to order are appropriate. Once with conservatorships, there's continuing court supervision. It is a highly court supervised, expensive proceeding. There are required accountings. The first one is due 12 months from the initiation of the conservative proceeding, and then biannually thereafter. And those are expensive.
Hi.
And those, to avoid some of that expense, once the revocable living trust that the substituted judgment order is giving us, once that trust is funded and the assets have been transferred to the trust, we can usually move to terminate the conservatorship of the estate while maintaining the conservatorship of the person. So that is how we handle this common scenario when we have somebody who's not our client and a client who is maybe the child of this elderly parent asking us for assistance in implementing an estate plan.
Would you say it's called substituted judgment because the court is giving a judgment that the person that they would have done these things if they had capacity, they would have made these gifts and executed this plan?
Yeah, I mean, it's called substituted judgment because that's what the statute says. But yes, that's what it means, precisely. Let's go to the next slide because we only have a few minutes left. And this is another tool in our toolbox, which we often use and you all should know about. And this circumstance is similar, but not exactly the same as what we just talked about in the conservatorship setting. So we have Allie and Noah, who are longtime clients of the firm. They have more than $50 million. Noah wants to make gifts to their children and grandchildren to reduce their taxable estates. But Allie is suffering from advanced dementia, lacks capacity to make financial or testamentary decisions, including the capacity to make gifts. So when you have under the community property law, both spouses have fiduciary duties to one another. And among those duties is the duty not to give away community property without the consent of the other spouse. And so here we have a situation, presumably if Allie had capacity and she knew about the impending reductions in the estate and gift tax exemptions, given the size of their estate, she may very well agree to making these gifts. But she doesn't have the capacity to do so. So we have come to the rescue, Probate Code Section 3100, a handy dandy code section which applies where we have one spouse who has capacity and the other spouse who lacks capacity, and allows us to petition the court for authority to make the gifts as if Allie had the capacity to do so without a conservatorship. So that's the key here, without having all of the expense and intrusion by the court of a conservatorship proceeding. So under 3100, we would file a petition. We would file it with a capacity declaration from a physician attesting to the fact that Allie lacks the capacity to join these decisions. We would demonstrate to the court, similarly to our substituted judgment petition, that these gifts can be made without any adverse impact on Allie's ability to care, for Allie's estate to continue to care for her for the rest of her life. And we would likely need to have the court appoint a guardian ad litem for Allie to represent her interests in the proceeding. And what I should have said in Scenario number 4, and I will say in scenario number 5, is it always pays to get all interested parties to consent, meaning with respect to the conservatorship proceeding, all of the adult children and grandchildren, and the 3100 petition, all of the adult children and grandchildren, and in this case, the guardian ad litem, to consent to the proposed gifting. And so this proceeding under 3100 is wonderful, as I said, because we can avoid a conservatorship in the right circumstance. And I've used this 3100 petition in dozens of cases. I've never had one rejected by the court. And so you should always keep this in mind when you have one spouse that can make these decisions and another spouse who cannot. Kim, do you have any comments on that?
I'm thinking. So I was thinking how it might be different if Noah wanted to do something that wasn't to benefit just the joint children of that they share together, and I guess that would be a more difficult situation. But I know that the court represents the interests of Allie in this case, or the person that is unwell.
Well, the court is protecting the interests of Allie
because
for
there's
sure.
a guardian ad litem.
Yeah, and so with the guardian ad litem, I mean, we've had interesting cases. As I say, courts have ordered these cases where it's not such a clear-cut issue, where the intended donees of gifts are children or grandchildren, but perhaps Noah wants to benefit others outside the family that are that the children are perfectly okay with. And Allie, of course, cannot participate. And so I've had the court, in appropriate cases with a guardian ad litem independent representing Allie, order the parties to transmute community property into separate property, where Noah would be able to make gifts of his separate property to people he wants to benefit, and Allie's separate property would be earmarked for the children, and there's nothing Noah could do to overturn that. So, as I say, those cases rarely come up, but when they have come up, in the few cases I can remember, I've gotten a court order to do that.
That's great.
So we're going to wrap up. I don't know whether any questions have been raised. Steve?
Yeah,
I put a question into the chat.
Yeah, I have one question here. Lori, perhaps you wanted to ask the question, as long as you unmuted yourself.
Okay, so I do estate planning. So I've run into a situation where you have a client who's been diagnosed with dementia, but it's not all or nothing. And talking with her, I feel confident that she understands the topic. Like, let's say appointing an agent under a durable power of attorney. She understands what that means. And I will, in that case, usually go ahead and do the work. So even though there is a dementia diagnosis somewhere, I feel confident in that moment, in that conversation, she knows what she's doing, even if this afternoon she won't remember it at all.
Yes.
I don't always do it, but that's my question, because I think that's a very real world thing.
Yeah. So having dementia, as you said, it's not an all or nothing. It's a continuum. In early stages of dementia, somebody can clearly have capacity, testamentary capacity, or even capacity to appoint an agent under a power of attorney. And I agree with you that if you've concluded that that person has capacity, to go ahead and do the work. If you have any concern at all, I would maybe recommend a geriatric psychiatric examination if you think it's going to be contentious. But otherwise, I think your conclusion that a dementia diagnosis doesn't equate to a lack of capacity is correct.
I agree.
Yeah. And that a person can have capacity in this moment and then maybe when she's sundowning not understand it anymore.
Yeah, absolutely correct.
Yeah. Okay, good. Phew.
Okay.
Thank you very much.
You did good.
All right. I know both of you have a hard stop at 1 o'clock, so I just want to thank you so much for participating today. I want to thank everyone for being here. Kimberly and Neil, I'm so appreciative of the time you took to prepare and present this. And I love the TV references. It made it very easy to relate to the topics. And I learned that even mob bosses deserve representation. Our next event is coming up Tuesday, November 5th, quite important date at noon with Michael Feisbohr from EY on gifting complex assets, benefits and rules around charitable gifts of real estate, business interest, and liquid property. He's a terrific presenter. I hope you'll be able to join us for that. And I will see you in a week when we do the next presentation. Thank you so much for all being here. And again, Kimberly, Neil, thank you.
Thank
You're
you
welcome.
for having us.